take their power. And the simple reason is because what we have done is we have only notified. If tomorrow is there any complication or confusion that arises, in case, which I'm pretty sure it will not, in that case, the district councils can easily go to court, and the section 4 and para 5 of the 6th schedule clearly defines the powers that the district council courts have. And hence, even if this notification were to be misread by somebody else in the future, the constitutional protection is there, which is fully there with the district councils, and hence there is no question of any kind of interference or any kind of overlapping or getting into the jurisdiction of the district council courts, and they will function as they were functioning before. And now the judicial magistrates will simply take over the work that was being done by the ADC judiciary, and this had to be done because now the ADC judiciaries don't exist. It's the judicial magistrates, and since they don't have powers, they can withdraw from the 1937 law, and hence this notification is required to ensure that the district session courts can function and the judicial magistrates can exercise their powers. So it's a very simple thing. We have called the district councils couple of times, and once I have chaired the meeting myself, and we have shared these concerns and points with them, and they have understood the whole point. So now the question of them mentioning about notification of exemption and all, it's already is exempted. There's no need for it to say, and the Constitution gives ample protection to the district council courts, and hence there is nothing to be worried and nothing to be concerned about. As I said, the objective of this notification is mainly and solely to ensure that the judicial magistrates under the district sessions courts can exercise their power, and it will not affect the powers of the district council.
But
So
the district council.
So in that case, is it that the district council did not want to understand, or they don't understand it?
No, that is not my area to respond to that. I'm sure that they have understood. I think they just want the notification to be slightly more clearer, so that tomorrow nobody uses this notification and tries to encroach into their power. I think that's what the concern of the district council is. But my reply to that is that, see, notifications, we can keep changing the words and keep changing and adding to it. But ultimately the biggest protection that they have is the Constitution and the 6th schedule itself. And para 4 and 5 have defined the powers in that, and they derive the powers from that. And hence there's no question of one notification of government of Meghalaya overruling the entire constitutional provisions, and hence we can keep making this notification better, but it's at 99%, for example, and they want it to be 100%. So I understand their concerns, but let me give the assurance to everybody that with this notification there will be no question of any kind of encroachment or interference into the functioning of the courts that are run by the district council.
But sir, the main concern of
Only
one last one, sir. But the main concern of the district council is the para 12 AA of the 6th schedule,
AA has nothing to do with this. Para 12 AA is to do
where the state laws will prevail over the district council laws.
But the Constitution prevails over the state laws. So the Constitution has clearly mandated in para 4 and 5, as I'm repeating, to give the certain powers. The governor has the powers to give this, to appoint judges in the district council or other judges and give them the necessary powers. And that cannot be superseded by a notification done by the government of